Good evening, this is John Milburn. This is Laws 11046, Law and the Environment. We're now into week 6 and we're dealing tonight with Strategic Environmental Planning and Assessment, which is chapters 8 and 9 of your text. The work that we're doing tonight really essentially relates to planning law, and that's the topic. There is the one problem for consideration, which we will talk about next week. Before we start to talk about that, just a few things, and I'm going to share my screen. I want to take you back, by way of reminder, to the court's website. The court's website provides some valuable information in relation to planning law. Now, I have shown you previously judgments, which is the text of judgments from Queensland courts, and you'll see that there. We've also done the search civil file facilities, and I want to show you forms. So if we go to forms over here, you'll see it will take you to a number of useful forms, which are in Word format. And what might be relevant in the context of planning law is the form that relates to an appeal from a decision of the Planning and Environment Court to the Court of Appeal. And that is under the Uniform Civil Procedure Rules, 1999, form number 69. So form 069 is an application to the Court of Appeal. Now, just by way of recapping, if you're involved in a planning dispute and the matter is considered at first instance, invariably it will be considered by an assessment manager, typically a council. And the council may call upon concurrence agencies to assist in the decision-making process. If you are unsatisfied with that decision, if you're the person who has made the application, or perhaps you're a responder, or perhaps you're the council itself, although I guess you wouldn't, sorry, I'll withdraw that comment, you wouldn't appeal against your own decision as the council. But if you are not happy with the council decision, then typically on a merits appeal, you would apply to the Planning and Environment Court. And in the Planning and Environment Court, we had a look last week at a case where you can actually see the documents that were lodged. And one of those documents was a notice of appeal, which is an appeal from the original decision to the Planning and Environment Court, which considers the matter on a merits review, stepping into the shoes, as it were, of the original decision maker to make the correct and preferable decision. For the terminology that we use. So for the Planning and Environment Court, it will make a merits review decision. Now, if you're not happy with the decision of the Planning and Environment Court, you can go to the Court of Appeal. So that's the next step up the chain of appeal processes. But here the character of the appeal changes dramatically. And if we look at a Form 69, you'll see what I'm talking about. The first thing is that you can't appeal as a matter of right. You need to seek leave to appeal. In other words, the Court of Appeal must be convinced that it's worth considering. So as part of the form, you need to set out the reasons justifying the granting of leave to appeal. In other words, you need to get your foot in the door and have them say, all right, well, that's enough of a case. We're interested enough to actually allow this to proceed. And the hard part as a lawyer, or in your case as a student studying a legal subject, is to work out what are the details of the decision of the Planning and Environment Court that are worthy of appealing and asking the Court of Appeal to reconsider. Now, the Court of Appeal will not consider this as a merits review. It's not going to start again and make the correct and preferable decision. It will consider the decision that was made by the Planning and Environment Court and then determine whether the Planning and Environment Court got the law right in relation to its decision. So you need to set out why the Court of Appeal should consider this, and typically it is on the basis that in some way the learned judge in the Planning and Environment Court erred by doing something or failing to do something, putting too much weight on certain things and not enough weight on other things, not following certain legal principles, such as the precautionary principle, or not giving sufficient weight to certain things in that regard as well. So there's a whole lot of different reasons why the Court of Appeal might consider the decision of the Planning and Environment Court, and that's the Form 69 that you need to use. So I just want to bring to your attention that that form exists, along with many other useful forms, and as we've seen, you're able to get to that via the court's website, which is always very useful. I'll just stop the screen now, and as usual, if you have any questions, please use the chat facility, or just unmute your microphones and we can go from there. The other thing that you would have seen is that we have the Australian Guide to Legal Citations, which is the way I like to have referencing, and the Australian Guide to Legal Citations, 3rd edition, is available on the Moodle website, and it's the first place that you should look is at the back of the guide. It's a quick reference as to how to cite some of the more common material that you might use. So that's always an interesting thing. There are some other readings that are available to you, but I don't think you need to go further than that. If you're really interested, let me know. And there are some extracts from the University of Sydney Law Library that is interesting as well. So what I might do is give you that extract, and I'll cut and paste that material, which is on my screen at the moment, and I might put that onto Moodle, Ucrew, and I'll do that as we speak. So if there's any questions, let me know. Otherwise, I'm just going to Ucrew now, and I'll paste that material, and I'll pin that to tonight. Okay, so that should, I'm getting there. Hopefully that will come through now. Okay, so that's the Australian Guide to Legal Referencing, or Legal Guide to Citation, Okay, now a really good website is the Department of Infrastructure, Local Government and Planning website. I'm going to show you that now, because it provides some really terrific information in relation to the planning side of planning and environment law. Again, I'll share the screen now. I think I have referred you to this in the notes that I've prepared. You should see the website there. You'll see that there's information about infrastructure. There's information about federal and state cooperation, and the material here is really first class. You'll see information about COAG, and that's it there, so that's COAG information there. All right, from planning, you'll see some excellent material in relation to plan making and development assessment. So development assessment takes you through the development application steps, and there's some excellent flowchart material which you can access through that material. So if you look at development assessment application steps, it provides you with information. And going back one step, if we look at development assessment process, it provides you with some excellent material. And what I might do is invite you just to have a look at that website. There's some excellent flowcharts that you'll find under the development application steps is the place to look for that. Okay. So just play around with that and you'll find some really good information. Okay, has some information about planning reforms and development assessment. Flow charts, that's what I'm looking for. Okay, so flow charts, this is really worthwhile. So is your proposed development exempt? Let's say no, and obviously you need to understand what each of these steps mean in the context of planning. Is your proposal self-assessable development? No. Is the application required to be publicly notified? Let's say yes, it is. Will the application involve referral to an IDAS referral agency? IDAS is the Integrated Development Assessment Scheme. So let's say yes, it does involve concurrent agencies. Is it likely to involve an information request? Let's be optimistic and say no. And then you can click this and it will show you the flowchart applicable to your particular development application. The beauty of that is that it provides very specific information, but it also helps to visualise the steps and the timeframes in a very easy way. So I'd suggest that you just play around with that for a bit. Obviously, it means that you need to understand the terminology and the processes on the way through. Okay, so if we go back to the development assessment processes, you'll see that there's compliance assessment development. The flowcharts, as indicated, make it easy in many ways. You will see reference to the State Assessment and Referral Agency, or SARA, and that is the acronym for State Assessment and Referral Agency. That is applicable where the state has a jurisdiction with respect to the development. So some development applications require the state to have jurisdiction, others do not. And if the state is involved, then you can look at SARA as having an interest in that. Okay, there's the various flow charts, etc. So a lot of really good information at your fingertips there. There is also the dispute resolution process, which is down the bottom of the page. So coming down, I've lost it, dispute resolution, and that involves the Planning and Environment Court or the Building and Dispute Resolution Committees. They hear certain low-risk technical matters, but the main one for our purposes would be the P&E Court. So it has some information there, access to the practice directions and the rules, court's website, which is going back to where we were, and the databases. There's also up the top resources, and I'd refer you to the Sustainable Planning Act forms. Let's see if I can, resources. I always seem to have all thumbs when I come to these websites. So resources, have a look at, there's the SARA, as I mentioned before. Here we have the Sustainable Planning Act forms, and that's a quick way to access the up-to-date forms, applications, etc. It's also got some tools over here, which is worth looking at. And the Planning and Environment Court database is also very useful. Okay, so I know that's a flying introduction, but really what I wanted to do there was show you that website, show you some of the ways to get around that website, and stress the importance of understanding some of those features. I'll stop the share now. One thing you would have noticed is that, and I've talked about delegated legislation a few times in this course, have a look at the Statutory Instruments Act in Queensland, that's in 1992. Section 15 of the Sustainable Planning Act states that there are a number of state planning instruments, so have a look at that as well. So statutory instruments are included as part of the overall planning instruments. And I know I'm moving fairly quickly. On the website and the notes, I believe, I've provided some information about environmental searches. So if you're involved in conveyancing to do with property development, then you'll need to know some of those searches, such as the Environmental Protection Agency, the importance of town planning certificates, and various other administrative advices that you will find on the website. Other than that, be aware that there are some things that you can't search, such as Greenhouse Gas Storage Act, information about that, and some things which affect the property are dealt with as infrastructure projects under the State Development and Public Works Organisation Act. That's State Development and Public Works Organisation Act 1971. That Act has effect in relation to certain major projects, and we'll be dealing with more of that during the week. During the course. Now, I know that's a brief introduction today. The material that is on the website in the notes is very extensive, so I'd urge you to look at that material. And what I want to do now is just go in and have a look at what people have been doing in terms of answering problems. And in particular, we've got the problems from week 5. And I'd just like to have a look at those as well. So if you can bear with me while I just share the screen. And you'll see laws 11046 come up on that screen. And we'll just have a look at what answers people have given in relation to that. Problem number 5. Hopefully we're getting a few. Okay, Raymond, Margaret, Luke, thank you very much. So this is to do with ecological sustainable development. And if you can bear with me, I'll just call up my notes in relation to that. Okay, so ecological sustainable development is something that you'll recall from last week is prevalent in many ways in environmental legislation, both at a state and Commonwealth level. And in dealing with environmental protection through sustainable development, we're dealing with international obligations that filter down through the Commonwealth and then through the state. International law governs the extent of sovereign rights of Australia, and some of the rights that are otherwise available to the Commonwealth are delegated to the states. For example, the states have power to deal with coastal waters out to 3 kilometres, and then it becomes the Commonwealth's concern. But that is something that was delegated, if you like, to the states by the Commonwealth. Ecological sustainable development is an example of where domestic policy and laws have been created as a result of international obligations that have been entered into in that regard. So ESD is something that you will see in various pieces of legislation. It may appear as an object. It may be that regulatory authorities in carrying out their functions are required to comply with ESD as part of their decision-making process. One little trick, make sure that you look out to determine whether it is simply ESD is something that must be considered by the decision maker or something where the decision maker must consider it. So the word may or must has a bearing on the extent to which a decision maker is bound to consider the issues of environmental sustainable development. Let's have a quick look at some of the answers. Okay, which is excellent. All right, so that's a good answer by Luke. And I'll leave you to read those other answers. And perhaps to add to that, it's not too late to do so at this stage. Okay, so by now you should be well into planning for your first assessment piece, which is due on the 5th of May. And looking down, we've got no submissions at this stage. Bear in mind that I won't read a draft submission as such, but if what is submitted by the due date is still in draft form, then that's what I'll answer. That's what I'll mark. So there'll be no ability to change what you've submitted after the due date, but I'd urge you to have that well prepared at this stage, but I wouldn't necessarily be too quick to submit it. You can always submit a day or two before the due date, just in case there's some useful discussions on UCRU or some other material that you come across. Okay, so I'll stop the share now. Thank you for joining us tonight, and we'll see you next week. All the best.